Good evening, dear participants. Welcome to the last but not least session of the day, the Symposium on Violence and Discrimination Against Women in the Context of Istanbul Convention, organized by Istanbul University Faculty of Law, Criminal Law and Criminology Research and Practice Center. We have 4 distinguished guests today who are joining us from 4 different jurisdictions to talk about a variety of topics that affect women, especially in the context of violence and discrimination. So without further ado, I'd like to present our first speaker, Professor Krisztina Karsai, who is a professor of law at the University of Szeged. And she will present a short report on Hungarian criminal law. Professor Karsai, the virtual floor is yours. Thank you.
Thank you very much. Thank you for the invitation for this really nice and really thoughtful event today. And even if it's late, I would like to share my thoughts about the topics that we have today concerning Women's Day and also concerning domestic violence and Istanbul Convention. I would like just to summarize that Hungary first joined the Women's Day call in 1913 already, and the very first celebration of this day was organized in 1914. And can you imagine, after the Second World War in the socialist era, International Women's Day was an obligatory celebrational day. And after the transition, the Women's Day lost its original labor movement atmosphere in Hungary as well. And also today, flower gifts dominate instead. It is a nice thing between males and female family members and so. And just a very recent information. We have right now lockdown in Hungary, but today, for this day, from the lockdown ordered on Friday, florists were exceptionally able to open today because of this nice custom to give flowers for women in the country. Okay. Anyway, tomorrow florists already closed, but today they, despite the lockdown, every florist were open. So concerning the Istanbul Convention, we have heard today a lot of thoughts and interesting discussions about the Istanbul Convention. And I would like to add some information concerning my country to this debate. Hungary has joined the convention in 2014, but never ratified it until today. And I must tell you that at the beginning, or actually until 2017, it was almost clear or not questionable that the country will join, the country will ratify the convention. But in 2017, the government and the parliament itself changed its view, and instead of discussing the financial issues, which was before the case, it started to discuss numerous arguments against the ratification on a more or less ideological basis. And that is the situation also today. I can summarize the main ideas and the main arguments, main counter-arguments why Hungary at the moment is not ready or not willing to ratify the convention. First of all, it is argued that the concept of the gender, the social gender, and the promotion of the gender ideology is in contravention with the Hungarian law and social concepts. Secondly, it is said that ratification of the convention would lead to discrimination against men. Thirdly, it's said also that if we would ratify the Istanbul Convention, then the immigration issues would be detrimental for women, because so can be protected the Hungarian women against mass immigration and against the associated violent crimes against women. So these are all ideology-based arguments, and the fourth argument is that Hungarian criminal law and criminal justice at all is enough protective and also preventive in this regard concerning domestic violence against women and men, and the criminal justice system is well prepared for these types of crimes and well prepared to protection. What are the facts? I can tell you that in Hungary, domestic violence or generally violence against women is a very it has high statistics. Just a couple of data. You can say that, for instance, only 1 in 5 women grew up in a family where her father beat the mother, or at least 3 women are killed every month by their husband or ex-husband or partner, or more than half of the murdered women were killed by their former husbands or partners. And there are also cases where men were killed by their partner, but statistics shows that in 80% of these cases, the woman perpetrator was preceded by prolonged severe domestic abuse on her part. Okay, so it means that the society is unfortunately hardly involved in violent acts, or in statistical data shows that women and people in relationships are often victims of violence. How criminal law itself is dealing with this issue. I prepared here another slide. I just would like to explain the main ideas, what you see here. First of all, it's important to underline that in the criminal code, we have indeed a complex and protective criminal law framework. And it means that the fourth argument of the government is a valid argument concerning the written law, how zero tolerance is given in the black letter law in the Hungarian criminal code. But you see here in the slide, I don't have enough time to specify all the details, that it's important that we have actually numerous criminal acts. You can see in the blue boxes, which are so-called normal or general criminal offenses. But in many cases, if the perpetrator, or if between the perpetrator and the victim there is a relationship, they are relatives from each other, they are living in a relationship, then we can take it as a qualifying circumstances, and in the majority of cases it brings more severe penalties as well. And indeed, it's very important we have a specific, a dedicated offense called domestic or relationship violence, which is characteristical in this, which is very important in the sense that not only the blue box offenses or behaviors are punished by this domestic or relationship violence offense, but also the last one, the orange one, if the perpetrator causes financial vulnerability for his or her partner, which is very characteristical also in domestic violence cases. And okay, then it can be said that actually the written law, the black letter law, is really exhausting in the sense that almost every aspect or every possible behavior which is criminologically understandable and imaginable is covered by the criminal law rules. But as we know, the devil is in the detail. I would like to address here 4 comments or 4 remarks concerning how this actually good construct, good statistical construct in the criminal code, how it is working, how it is functioning, and how its dynamic is not so bright than we can read it in the law books. So first of all, you might know, or it's very important that in the case of causing bodily harm and the case of non-qualified domestic violence and the basic offenses, the private motion of the victim is necessary. But we know that Istanbul Convention requires just a low threshold intervention by the authorities, which is not depending from the victim's motion or actual activism in reporting the case towards the authorities. So it means that in cases where the private motion is a requirement for launching a criminal procedure in case of non-qualified domestic violence, then we see often that victims are not willing to bring the case before the authorities, or first they bring it there, but afterwards they try to withdraw the motion. I will give the second remarks concerning this. So that is first of all the first remark concerning the private motion. Still, we have offenses of domestic violence where the private motion is a requirement. Meanwhile, Istanbul Convention says that it's not a good thing. You have to, I mean, you country, participating country, you have to establish a low threshold concerning intervention. Secondly, concerning this private motion requirement, we have indeed steps forward, but in reality, in cases of qualified domestic violence, sometimes law enforcement authorities are still requiring the private motion. These rules are already in force since 2013, almost more than 7 years. But still, we have police officers, law enforcement officers who are not really understanding the difference between qualified or simple domestic violence, and therefore also in very severe cases they are requiring the private motion. And I must tell you, even if there are numerous programs, training programs and programs for sensibilization, but maybe 7 years is not enough. Further years are necessary in order that everybody, or in every heads in the members of among the members of the authorities will all aspects of this topic clear. Thirdly, I would like to mention a very specific procedural aspect, but I think it must be or should be similar in other jurisdictions as well. Namely, that if we are speaking about crimes between relatives or in a relationship, it's really a different issue in the sense that the evidentiary process, how to prove what happened, that is more difficult than in, I would say, average cases. Why? Because often the perpetrator is denying fully, and only the victim has is in position to provide evidence against the perpetrator. But in these cases, in the majority of cases, the judges find themselves in a situation that if they can find somebody, if they convict somebody, they convict this perpetrator based on indirect evidence. And indirect evidentiary procedure is a well accepted evidentiary procedure, but it's a totally different. It requires a different way of thinking, and in such cases, if the defendant is in full denial, the indirect evidence like Facebook posts, messengers, the testimony of friends, testimony of neighbors could be relevant, but all these evidence are often only of indirect matter, and it's not so easy to understand for the defendant or to accept for the defendant that he or she could be convicted also based on indirect evidence. And the fourth one, which is, I think, very important procedural change, it has changed 2 years ago with introduction of the new criminal procedural code in Hungary, namely that we have now new rules on the right not to be questioned as a witness statement. What does it mean? That if once a witness has brought a statement, then the withdrawal rights, how to withdraw the statement in the further stage of the procedure, are not so easy than before. Actually, it means that the testimony of a witness given earlier in the same case or in another case can be used as a means of proof, even if the witness refuses to testify later. And in domestic violence cases, when first maybe the victim gives a testimony, then later withdraws it, okay, can do it, or not, or remains silent as a witness in the further stages of the procedure. But because of this new amendment, at least the facts of his or her testimony can be used later, which could be a very good lead for the judge how to move forward with the evidentiary procedure in the trial. So to sum up, it means that indeed, if you look into the black letter law, then you can see that this fourth argument, which is not an ideological argument, which is a professional argument based on the Hungarian government or parliament, it's a valid argument. In the criminal code, we see a very comprehensive and I would say a strong protection against these crimes. But in reality, and also we have some procedural rules which can be used and which help to move forward effectively if at least already the motion is given and the authorities have the information about the case. But sometimes, or many times, or sometimes we see that still authorities are not really prepared, especially in the law enforcement period, not properly prepared. But indeed, there are also programs or projects for training and sensibilization. And my last remark, against ideological arguments, there is no professional argument. If Istanbul Convention is labeled as a convention which contains an ideological aspects which is not acceptable for from a political point of view, from an ideological point of view, clear legal arguments cannot be footed on this argumentation. But indeed, for us, I mean, law professors and other professionals who are dealing with such issues in theory and also in the frontline professional work, we have the task and the duty to address in every second or every possible situation these contraventions. But indeed, if it's about ideology, the professional legal arguments cannot stand. So thank you very much, and I'm open for your questions.
Thank you very much, Professor Karsai, for this great and critical overview of Hungarian law. I could not help but spot a lot of similarities between the issues we have in Turkey, primarily legal and structural issues, despite the fact that Turkey is a party to the Istanbul Convention. So perhaps we could discuss that during our Q&A session. So thank you again. So now we will move on to our next speaker, Professor Lucia Parlato, who is a professor of law at the University of Palermo. And she will speak on another very timely topic, which is domestic violence and the COVID-19 pandemic. Professor, the floor is yours. I believe you're on mute.
Hello, good evening. Thank you for this invitation. I am very grateful, and yes, I'm going also to speak about some criminal procedure issues and how you thought. I come from Italy, and today is Women's Day in Italy. Today is the so-called Festa della Donna. In Italy, the importance of women is today celebrated by giving and receiving mimosa flowers. This tradition probably began on March 8, 1946. And yes, here we have this mimosa blossom. Then I have put together for this discussion some points. First of all, Italy and the Istanbul Convention, then definitions, questions and shapes, then domestic violence from now DV, and the COVID-19 pandemic. It is a complex relationship. Italian statistics, final remarks, and keyword time. Well, the first point is the relationship between Italy and the Istanbul Convention. My country, Italy, is a party to the Istanbul Convention since 2013. And the debate regarding the convention is mainly focused on 2 points, on 2 sides. Equality issues and the protection of particularly vulnerable people. Then, on one side, domestic violence result as an inequality issue. here we can consider three interconnected perspectives. First of all, a previous condition of vulnerability of victims, also because of the gender issue. The second perspective regards the status of the family and relationship with the external world, but we can say that DV is really a transversal issue. It often happens in the highest strata of the society in Italy. Anyway, DV makes worse the already existing inequalities or creates new ones. How I say the DV is also a particular vulnerability issues. That is because domestic violence generates particularly vulnerable victims. There is an interesting definition of particular vulnerability contained in Directive 2012, number 29 on victims' protection. And the appraisal of the particular vulnerability status requires an individual assessment. One of the main factors which play a role in this definition is the close relationship between the victim and the abuser. And it is very interesting for our topic of today evening, domestic violence. In Italy, the legislator, following the convention, approved the law number 77 of 27th June 2013, and introduced in criminal procedure code dispositions on vulnerable witnesses protection and on victims' rights in the frame of non-legal procedure. The legislator in 2013 modified also the legal aid law and provided the victim of some gender, sexual, domestic crimes with technical defense paid by the state. That was according to the Article 57 of the Convention of Istanbul. More recently, we had another reform. It is a very interesting reform, the so-called Codice Rosso, law number 69 of 2019. And this law introduced new norms in criminal code and in the criminal procedure code as well. In particular, now the victim of gender and domestic violence must be heard within 3 days after the investigation beginning. With this reform, the legislator introduced new crimes, and in particular, the so-called revenge porn. This new crime is added to the already existing stalking crime, and the stalking crime is now harder punished. So we can find now a definition of domestic violence. This definition is a mobile definition. We need a mobile definition with blurred boundaries and not a clear-cut one. We can move from the Article 3 of the Istanbul Convention. It contains two definitions: definition of violence against women and of domestic violence. Moving from the first definition of violence against women, we have to add something and to remove something else, and we can do it. We can do that through some questions. We can consider a couple of questions. The first question is, who is the victim of domestic violence? The victim of domestic violence is the woman, of course, but not only women are victims of domestic violence. We find also children, and a specific problem regards the case in which children witness crimes. Are they also victims? It is not only a theoretical problem, but it is also a practical one, has a great impact, because if we consider these children really actual, like a victim, they are bound to give evidence, notwithstanding their close family relation to the accused. And it happened in Italy thanks to the so-called Codice Rosso. Anyway, the presence of a minor during the perpetration of a crime results in the application of an aggravating factor. Yes, another question is where, not only at home. What about women who don't cohabit with the perpetrator? We can include anyway these victims in the definition of victim of domestic violence. Shapes. Domestic violence can have many shapes. The conducts that can be labeled as domestic violence are many, devious, many shapes: physical, sexual, psychological, economic stalking, and cyber violence is or can be a form of domestic violence as well. It is confirmed by a central decision of the ECTHR on the Buturuga case. Yes. Another point is, how has the COVID-19 pandemic affected DV? Many factors work together in this era to create difficult or even dramatic life conditions within families and intimate relationships. Normal factors and more severe factors worked together. And because of these factors, we can say that staying at home became dangerous instead of being a protective solution. And it is peculiar that the increasing cases corresponds to decreasing reports. So at the same time, there are more cases, but the number of the reports is decreasing. What does it mean? we can say that there are many factors which play a double effect. So there are some silent factors, but these factors are also the reason of the increasing of cases. The factors are different. This list includes the close contact between the victim and abuser in terms of shared space and time. In particular, the loss of social control plays a very important role, and the separating of cohabitants becomes extremely difficult even upon judicial decisions. The Italian statistics, Italy seems to be a very safe country. Yes, we can consider a report provided by National Institute of Statistics. The reference period is 2018-2019, and the date of publication is very recent. So there is a decrease of murder cases, but if we consider the convicted people, in a very high percentage, they are men and not women. There is at the same time an increase of murders in the frame of DV cases. And it is interesting to study, yes, to observe. Possible remedies. What kind of remedies can we imagine? We have to imagine new ways to enable victims to report the crime and to access help. We need perhaps scripted methods to report crimes. For instance, I can remember two examples. The first one regards an interesting story happened in Torino before the quarantine. It's about a woman and her 10-year-old child, both victims of domestic violence. The woman pretended to order a pizza while she was actually calling the police. The police officer who took the call understood it wasn't a mistake or a joke, but a crypted way to ask help. Another case regards the quarantine era, and it regards a peculiar way to ask for help in cases of domestic and gender violence, namely asking for a 1522 mask in a pharmacy. Yes, it could be a crypted way to ask for help. Then perhaps we need for a more social control, but a problem is the issue of privacy. Among the possible remedies, we can mention also the precautionary measures. It is very difficult to use a precautionary measure, and during the lockdown, we need places or institutions to host victims in extreme cases. The suspected it is difficult to apply first the departure of the suspected from the family in this moment, even if the violation of the judicial order in Italy now represents itself a crime thanks to Codice Rosso. Final remarks, yes, these final remarks regard some cases examined by ECTHR. In particular, we can remember the Tershana versus Albania case. It is very interesting because it clearly confirms a positive obligation for the states, an obligation to do, because yes, the authorities must conduct a prompt and effective investigation into identification, prosecution, and punishment of the assailant. Another case, very interesting, is the Volodina versus Russia case, but I go now to consider Talpi's case. Talpi's case regards directly Italy, and the court affirmed that the passage of time can compromise the investigation and prevent its successfulness because of the loss of evidence. It is very important. So the key word on this topic is time. In domestic violence criminal proceeding, the time is the core of the criminal proceedings issue. Yes, in criminal proceedings often occur two factors. On one side, delay in reporting the crime facts, and on the other side, we can consider a very strange declarative progression, very intermittent and discontinuous. But we have to stress a recent decision of Italian Supreme Court. Italian Supreme Court clarified that these factors are not able in themselves to undermine the reliability of the victim as witness. So it is important to stress this point because the victim needs to manage the time during criminal proceedings, and it is very relevant to protect victims from themselves. They have to manage the time to make a report, and then to consider to delivery her declarations. So at the end, thank you for your attention.
We thank you, Professor Parlato, for this very elaborate presentation, touching upon a variety of topics which are all very essential and crucial. And in particular, thank you for presenting some remedies and solutions as to how we can overcome some issues. And surely they will be very valuable to other jurisdictions as well. So now we will move on to the last presentation. We have two speakers who will be presenting jointly on the topic of common myths about sexual crimes. So Assistant Lecturer Sophie Marsh from the University of West England and Assistant Professor Rahime Erbaş from Istanbul University Faculty of Law. They will be presenting on common myths about sexual crimes. And now I hand it to you. Thank you. I believe you're on mute. Professor?
Thank you so much for having me and for giving us this opportunity to bring this important topic to the arena. So this is important. Again, I just would like to welcome everyone and good evening to everybody. As I would like to say, I don't want to repeat many things. Just I want to say, I and Sophie Marsh, we are going to have this speech jointly. I just would like to introduce my colleague, my distinctive colleague, Sophie Marsh. She is an associate lecturer in law and criminology at the University of West of England. She is currently doing her PhD under the supervisorship of my co-editor, Edward Johnston. In her PhD, Sophie critically analyzes the impact that misconception of sexual violence, which have on the high level of attrition in England and Wales. Her research interests include criminal justice, criminal procedure, and sexual offences. Today, I and Sophie, we are going to talk about this common myth about sexual crimes which lead to attrition in sex crime. It means sexual crimes remains in the dark figure of crime because they are underreported, because of the fear, shame, and also because of these myths, common myths. The women they refrain from reporting this criminal act. Firstly, in our speech, Sophie will speak briefly on this attrition concept. What is attrition in this rape issue and its effect in England and Wales? Then she explained what an attrition in sex crime means theoretically, what is the impact and influences of attrition. Then she described what is rape myths, and also she brings the discussion this rape myths definition in the literature. And then after the Sophie, I will indicate some example of these common myths about sexual crimes in Turkey by benefiting some empirical research. And I discuss them, and then I will list this important, very strong common myths. And then finally, I and my colleague will discuss some prevalence of these myths in our criminal justice system, and that brings us at the end of our speech. So I'm just letting to take over the Sophie.
Thank you very much, and thank you for inviting me to talk at this conference on International Women's Day. As Rahime said, I will be discussing the effects of rape myths on a concept that we call attrition in England and Wales. England shares its legal jurisdiction with Wales. So to set the context of sexual violence in England and Wales, it's reported that 1 in 5 women over the age of 16 have been subjected to sexual violence in England and Wales. So again, like the other countries discussed, we are experiencing very high levels of sexual violence in England and Wales. So moving forward, what is this concept of attrition? What do we mean by attrition? Well, attrition refers to the case dropout throughout a number of different processes in the criminal justice system. So it refers to the lack of case progression for a number of reasons, which I will discuss in a moment. So why might this attrition and case dropout occur? This can be for any number of reasons, and this includes, but it's not limited to, the victim's failure to report to authorities in the first instance. Once this crime has been reported to the authorities, the complainant may withdraw this allegation, amounting to a case dropout. The police or the CPS, our Crown Prosecution Service, who bring the charges against the defendant, may be unwilling to proceed, and that's usually regarding a lack of evidence, and certainly other reasons too. And another important cause of this attrition is juries not returning a guilty verdict. And again, this may be due to a lack of evidence or these myths that Rahime and I are going to discuss. So what is the impact of attrition on our criminal justice system? Well, England and Wales are experiencing incredibly low reporting rates and therefore low conviction rates. It's assumed that just 31% of victims report their experience of sexual violence to police, and so therefore it's assumed that almost 70% of victims do not ever disclose this experience of sexual violence to authorities. And it's important to note that such disclosure to the police of sexual violence may not be a recent experience. This can be a historical experience, which can amount to decades of somebody not disclosing this crime committed against them to authorities. Of these 31% of cases that we believe the police are aware of, just 33% of those, so roughly a third of those, actually make a referral for prosecution, where the police will refer this to the CPS for charging. And actually just 3.2% of those referred to the CPS actually result in prosecution. So we have an incredibly low prosecution rate here, where the defendants are being charged with an offence. Of those that are actually prosecuted, the conviction rate is slightly higher. It is 50%, around roughly 50%. But considering that just 3.2% of cases result in prosecutions, of those actually prosecuted, it's suggested that around just 1.6% of those cases are actually, they actually result in a conviction and a guilty verdict. So what are the influences of this attrition and this case dropout, low reporting rate, low conviction rate, etc.? Again, there are a number of reasons, these are not limited, but they may include the type of case. For example, whether it's an acquaintance, a domestic setting, a stranger, or a historical case. And therefore that includes the relationship between the complainant and the suspect. This may include the vulnerability of the complainant, and in particular, the influence that we'll be discussing today is perceptions of sexual violence, both in the public and within our criminal justice system. And this is what we call rape myths. So what do we mean by rape myths? Well, Brown-Miller first introduced the concept of rape myths from a sociological perspective in 1975, and he referred to them as the canons of the dirty jokesters, and said that they deliberately obscure the true nature of rape. In 1980, Burt further clarified this and provided us with a definition of rape myths. And Burt defined them as prejudicial, stereotyped, or false beliefs about rape, rape complainants, and rapists. So he reiterates there that they're prejudicial and stereotypes. These are false beliefs. In 1994, Lonsway and Fitzgerald further defined this definition, and they defined rape myths as attitudes and beliefs that are generally false but widely and persistently held, and that serve to deny and justify male sexual aggression against women. And so they reiterate that there's common gender roles there involving male sexual aggression against women. And more recently, Gerger, Clay, Bonner, and Siebler have defined this concept of rape myths as descriptive or prescriptive beliefs about sexual aggression, i.e. its scope, causes, context, and consequences, so a number of different elements there, that again serve to deny, downplay, or justify sexually aggressive behavior that men commit against women. So to summarize these definitions of rape myths, whilst they develop over time, what's clear here is that they act as barriers to criminal justice and to the progression of cases of sexual violence throughout the criminal justice system. Here are some examples of some common rape myths in England and Wales. So a very common rape myth is that the complainant will do all that they can to fight the attack off and to resist the attack. And actually research in England and Wales suggests that 81%, so the majority of complainants, do not resist their attack. And so the research directly contradicts this rape myth that's very commonly and persistently endorsed and believed. Another rape myth is that the perpetrator is usually a stranger. And in reality, the research suggests that 90% of sexual violence is committed by somebody known to the victim. So again, this research completely challenges this rape myth. Another myth is that the victim will report to the police immediately. And we've already covered that it's assumed that just 31% of victims of sexual violence will report to the police in their lifetime. And this certainly may not be immediately, this may be decades later. There's often historical cases that are brought to light. And some final examples, there's a common myth that the complainant lies about the rape, when actually the literature suggests that false allegations amount to around 2 to 8% of cases. So a very small minority there. And actually, a false allegation does not always consist of a lie. So it does not mean that the complainant has fabricated the complaint. There may be other factors at play there. It's not necessarily a lie. And the final myth that I'll be discussing today is that alcohol consumption amounts to responsibility for sexual violence, when actually, in reality, alcohol consumption completely removes the capacity to give informed consent, which is an element of our law in England regarding whether or not somebody has provided their consent to sexual activity. So we've established the prevalence of rape myths, and now it's important to discuss the impact that this has on the criminal justice system in England and Wales. So the research suggests that police officers are actually more likely to endorse these rape myths than members of the public. One particular study by Dr. Jessica Taylor suggests that one particular police force, 80% of those police officers agreed with these statements, these rape myths. So we're talking about very high levels of endorsement of these misconceptions, these incorrect beliefs, these false beliefs. And so the question we need to be asking ourselves is, do these rape myths impact criminal justice? And therefore, is there a solution to this issue? Now, I'm currently in my second year of my PhD. As Rahime said, I'm analysing the impact that rape myths have on this high attrition level. And my research will uncover the extent to which these rape myths are endorsed throughout different elements of the justice system. The police, the Crown Prosecution Service, the judiciary, the lawyers. Unfortunately, in England and Wales, we are not able to research jury decision-making due to the element of jury secrecy. And so it's very difficult to ascertain the extent to which jury members are endorsing these rape myths and the impact that these rape myths have on their decision-making, and therefore whether these rape myths impact the guilty verdict or the acquittal of the charge. And this is something that Rahime and I will discuss together after her speech. And finally, here are some of the references that I used.
Okay, Sophie, now I will continue. Thank you.
Thank you.
As Sophie explained very well what rape myths are. These are very difficult to define, as Sophie discussed some professor opinion in the literature. In Turkish law also there are, in Turkey there are remarkable amount of study, especially empirical study about this rape myths or myths, common myths about sexual crimes. But in terms of in psychology, in other fields, sociology, for example, in other social sciences, it is tackled very deeply. But unfortunately, in the legal sciences and also criminology in Turkey, there is a limited study. For me, for example, just I want to emphasize, highlight some aspect of this rape myths issue. Why these rapes and why is tackling these rape myths are important? And because of course there are some myths also against men also as well. For example, only women can be victims of these sexual crimes. For example, this is another myth also against the man. But mostly these myths, these common myths generally target women. And then our main question in this regard, why are women blamed for sexually aggressive behavior of men in this context? So these are kind of stereotype, and these are roles about the role assigned to man and woman by society in generally. These contain many beliefs about crimes against sexual immunity, and of course these myths doesn't correspond to real events. More importantly, these myths deny and also justify this sexual aggressive behavior of man. Therefore, it is very important. So for here, it is very important to emphasize in our former penal code, as it is in Italy, in also the Codice di Zenardelli, also in many jurisdictions. Sometimes we discuss with Sophie, sexual crimes historically was accepted the crime against society's moral ethics. So it is very new in many jurisdictions, also in Turkey, sexual crimes is considered as a crimes against individual sexual integrity, sexual freedom. So therefore, seeing that this concept, new concept, so young, and therefore it is very clear and understandable how much, how deep these myths has a role in our society. Therefore, it is, I think, very important to emphasize, of course, patriarchal society, male-dominated society also here play a role also. I just want to give some example from our literature, from our empirical studies conducted by sociology and psychology. For example, the woman who wear sexy dress or clothes which are revealing the body provoke sexual crimes, for example. This myth also based on idea sexual crimes is committed, a crime is committed because of a sexual passion, sexual desire. This is also another myth, because there are a lot of study what is why on the reason of the why sexual crimes are committed. It is very there is a huge debate in literature, but one thing is sure, sexual passion, sexual desire is not only or the common reason for committing this crime. Yeah, therefore, also this is also related that a man is not cannot be victim of this crime. So yeah, this is the dress issue, also a very existing one. The second one is maybe another belief in society. There are some women in society, they deserve sexual assault, for example. Another one, also Sophie mentioned about this, drunk women have a lust for sex. And also the women who go out night take a risk of being raped, for example. If a healthy woman doesn't fight back or doesn't show any resistance, it shows that she wanted to have it, for example. For example, all sexual crime victims will report the crime. If a woman not inform the police immediately, if it means she lies about it, for example. Another myth about, I related this one, sexual crimes mostly occurred in public spaces. Yeah, this is also another tough one. The other ones, for example, women with disabilities are at low risk for sexual crimes, or women who are at senior age are also low risk for sexual crimes. Another persistent one is if a woman goes to someone's room, house, or bar, she assumes the risk of the sexual crime, for example. Yeah, unfortunately, these are exist in our society. Another important one, if a woman accepts a gift by a man, it means she consented to have a sex. Women who are not virgin doesn't have any damage due to sexual assault. Another one which is very related, this one, women sex workers cannot be raped because they are selling sex already. Regarding this myth, for example, in our during the application of our former penal code, there is a punishment diminishing ground for it. If the victim is a sex worker, perpetrator takes diminished punishment, for example. And another important one, even today we discuss a lot, a woman cannot sexually assault by spouse. Most sexual assaults are committed by strangers. So this is another very persistent one, because according to a study conducted for Turkey by the Women Against Violence European Network, this study showed us, this study conducted in 2014, it shows that the women who married in Turkey, 12% of women informed they were victim of this marital rape. So this is another problem. Also, another empirical study conducted by in Turkey, it says, for example, if a man has a sexual problem, it is because of women. So regarding this myths, for example, the participant of questionnaire, 50% of the participant of this questionnaire answered positive regarding for this myth, for example. And regarding another question, if a woman rejects sexual intercourse, sexual relationship, the husband has a right to beat her, for example. 37% of the participant of this questionnaire says yes, this is right. Regarding this myth, for example, this false, unfortunately, very violence behavior things. So this is, I just want to say all about in our society, these are problems, but of course I have to emphasize there are a lot of myths also against male, but most of them against women. Also we see this in Istanbul Convention. Also Istanbul Convention in preamble emphasizes there are gender-based violence and mostly women are the victims. Women mostly higher risk for the gender-based violence in our society. So for concluding, to sum up, my opinion is that although in our former penal code, sexual crimes were considered as a crime against moral of society, so therefore these myths are very strong. Also found many application in the concrete case law. But today we see these effects of this myth very slightly, and on the other hand, this slight effect render us difficult to combat its effect. So this is my conclusion regarding our study. So now I just give words to Sophie to end our speech. Would you like to say to conclude?
Yes, thank you, Rahime. So to conclude our joint presentation, it's evident that the prevalence of rape myths is very high in both England and in Turkey, and therefore these myths justify sexual violence and sexual aggression, particularly against women, although it's not limited to male victims. This therefore impacts criminal justice by limiting the amount of prosecutions and convictions that we are having. And it's suggested that a cause of this is potentially the patriarchy. And so it's really important that we have been able to bring awareness to this issue on International Women's Day. So thank you all for inviting us to discuss this really important topic with you all this evening. And we would like to answer any questions that you have. Thank you.
We thank you for this very valuable contribution, which is very fitting, especially for our panel, because it's done from a comparative law perspective as well as an interdisciplinary one. And I'm sure we will have lots of things to discuss, both from a legal and sociological point of view, among other views. So thank you very much once again, Professors Marsh and Erbaş. So we will now move on to our Q&A and discussion session. We have reserved 15 minutes. So I will check if we have questions from our live stream on YouTube. So our first question is from Yusuf Görgün. So he thanks the panelists for their speeches and asks a question to Professor Karsai. So he expresses that one of the reasons for not ratifying the Istanbul Convention in Hungary is the existing legal framework, which is believed to be sufficient. And he notes that the Istanbul Convention is actually a sort of like specialis. And he asks how is a distinction between special law and general law applied in Hungarian law? So under the assumption that the Istanbul Convention has been ratified, what legal regulation will be applied in Hungary in terms of crimes against women?
Thank you for the question. Actually, I would say that I didn't mention it, but this new framework of concerning mainly concerning the sexual violence and also concerning the relationship or domestic violence is in force since 2013. And even we can observe that during the codification process, we have new criminal code from that time. And during the codification process, the legislative body was aware about the Istanbul Convention. And that time, such ideological contraventions or counter-arguments were not represented. So therefore, many of the issues what we see right now in the criminal code are coming from the, or we can say that both from European Union requirements, but also from the Istanbul Convention. Even that there is no crime which would make any distinction between male or female perpetrator or victim. But for instance, what I mentioned in this regard, the private motion institution, which is more or less a higher threshold, what is expected from the Istanbul Convention, that should be abolished in certain circumstances. And until Istanbul Convention will be not ratified in Hungary, I understand your question concerning special and general law. It's not relevant because only criminal code is in force and criminal procedural norms are governing the proceedings. So international conventions cannot based on the doctrine in Hungary, cannot influence the legal everyday criminal law, because if they are not ratified, then they cannot have force in the cases. But as I mentioned, that during the new recodification of these type of crimes, the legislative have at least one eye on the Istanbul Convention.
Thank you very much. So now we will move on to our next question from the YouTube stream. So one participant asks, and this is not directed to any of the speakers, so feel free to answer this. So our participant notes that there are many NGOs working on the prevention of crime against women, and they organize many awareness-creating events. And our participant asks if you think these events have any long or short-term positive impacts on the prevention of crimes against women in general. So the role of civil society, perhaps, in the prevention of crimes against women. Professor Parlato, maybe an Italian perspective, perhaps? I'm very curious.
Yes. It could be very important to prevent this type of crime, that women have not to remain alone, and this forced isolation in the current time is also dangerous. So we have to avoid to start isolation in this time. And in order of the need to protect the victim from herself, as I said, it is very important also to explain on the cultural side that women have to understand the significance of the offense. Because sometimes it is too difficult to understand that the situation is very dangerous, and that it could be suitable as a crime. It is also very difficult. So we need that on the cultural side, victims know that there is something to report, there is something to complain, and that they have not to withdraw the complaint if it is lodged. Yes. So preventing crime means also work on the cultural side, I think.
Indeed. Thank you very much, Professor Parlato. I believe.
Thank you very much.
I believe this answers the question of our participant. So now we have a question from Professor Karsai. Professor, please go ahead and ask your question.
Thank you very much. During your speech, Mrs. Marsh and Erbaş, I was ongoing thinking about the myths, what maybe in Hungary and the Hungarian population, what are in the heads. And a lot of your myths are well known also here. And my question is, what do you think? That is also a question to me and to all of you, because we are here law professionals or criminologists, experts. How can we combat against these type of myths? Just one footnote, because legal norms are not often enough precise to catch this type of, I would say, bad thinking. Is that? Then how can we move forward to abolish this type of way of thinking, and for what time period can we have the chance to abolish it? Just, yes, that is my question. Maybe just, yes, what is your opinion concerning how to move forward, and how to move forward if once we know already about this phenomenon?
Sophie, would you like to express first? And okay, then I will.
Yeah, sure. I think it's very difficult. Currently, the research that I've looked at with regards to using education to challenge these myths and to educate people, and the examples I gave there, the myths versus the reality, the research has suggested that actually this kind of education has had little to no impact on the prevalence of these myths. So that raises a lot of questions with regards to moving forward. Ultimately, I don't think we have the answer to this yet, and there is a huge gap in the research there. I hope that my PhD will be able to bridge this gap and offer a solution. But whilst this is a relatively sort of undefined approach, it is suggested that what's really needed is a cultural change as opposed to education. But unfortunately, there isn't really an answer to this at the moment. And I think this is why it's really important to bring this issue to light today, because hopefully it can spark some discussion and make a positive impact. I'd like to hear your thoughts on this too, Rahime.
Yeah, I don't know how is Hungary, but I think this our old concept, sexual crimes, is considering this sort of crime as a crime against society, moral, and we changed this concept very newly. I mean, not only Turkey, also in Italy, Codice Zanardelli was the same. It is a cornerstone to break this myth's connection with the law, because when we consider sexual crimes as a crime against society, moral, so they have a huge impact from these myths, and even application, even rules. For example, in our old codes, I mean, if the victims are sex workers, so the perpetrator takes less punishment, for example. I mean, it's a big, I mean, a cornerstone. Considering this crime is so, there is a break from myths, but in reality, for example, in some cases we see if the victim doesn't resist, in terms of evaluating this, the concept of consent, for example, whether there is a consent or not in this discussion, for example, whether victim resisted or not, for example, this is a criterion in some cases. This is an impact, a slight impact of this myth. So therefore, I believe today it is much more difficult to combat with this myth because it is much more obscure. So I believe NGOs or something maybe have a role. It is also interesting, Krisztina, because these myths mostly target women, not men. This is also another problem. Why there is a myth? Okay, they are bad. They are, but why against women? Why they are targeting a woman? This is also another aspect. Of course, there are some myths against men, but they are limited. Yeah, I am not, of course, advocating there should be myths against men. This is, of course, but this is another issue. So I believe in this regard, for example, if a woman dresses provocatively, she provokes this crime of sexual. So in this regard, maybe we have to show the society what is a real reason of the sexual crimes. For example, there are many grounds such as sadism, also psychopath, and also other things, also lack of self-control. There are also cultural impact. Also, there are lots of empirical studies. They are discussing what is the accurate reason behind these sexual crimes. So this is another issue, I think.
Yes, but please do not forget what is the reason, what is the ground of sexual crime, the free will of the perpetrator. I don't believe okay, we can do a lot of research concerning behavioral research and so, but until our criminal justice and criminal law is footed on the free will, why should we look for explanation and justification in sexual behavior?
No, not justification. I mean,
yes, I fully understand what you mean, but free will, it's just the free will of the perpetrator to be violent or not, no?
Yeah, of course.
And maybe let me, if you allow me, just you mentioned already, Mrs. Marsh, that education, maybe it would be very important, but not so effective yet, or I don't know. Yes, public discourse, very important. What we can see in adverbs, in movies, or in the television. If you allow me, maybe 2 sentences. A very recent case we had. It's a very good stuff, because the public discourse in Hungary, it's not so nice in the last couple of years. The limits are more and more less concerning how we argue in domestic violence cases, what politicians let themselves, how to speak about these issues in a very wrong direction what we have. But we had this Big Brother type fancy TV show. You understand? You know what is. And one actor, one participants, a male, was really verbal violent with another participant, with a woman. And can you imagine what happened? Okay, some NGOs were raising their voices that it cannot be broadcasted and more about this type of conversations. And the TV channel organized, okay, they didn't shut down the show, but they organized some roundtables with NGO representative, with lawyers, and with psychologists. They made a very nice and very deep discussion. And of course, afterwards, they tried to mix up this special participants. Okay, revolutionary decision would be if they should shut down after this case, after this very bad situation, the movie. They didn't do it, very bad, but at least they tried to do something in order to make it understandable for the audience that what happened, it's a bad thing, and how can we move forward. But as I mentioned, the majority of the women organization, and also how to say, moderate professionals said, okay, that was just a nice try to rescue for the channel, for the TV, but at least something. But this is also very characteristic for the discourse, public discourse, how it can be changed and what kind of bad consequences this change can have.
Krisztina, I absolutely agree with you because we discussed a TV series in Turkey. It's a TV series about there is a sexual crimes and committed a lot of lots of men, and one of them marry have a also it's a kind of love affairs, and then you see, yeah, there are some movements for women feminists in this film series, but on the other, they show display a love affair with this the guy, one of the participants of sexual crime. So in my class, we, for example, discussed. This is, for example, one of them. They also, normalize the situation. For example.
Mm-hmm.
Yeah, thank you for asking question. Very important. I am totally agree with you.
Thank you very much all for your comments and remarks, and in general for your speeches and for being with us today at the end of the day. So today, during this panel, as well as throughout the symposium, we discuss very crucial topics affecting the lives of women from legal, sociological, psychological, and societal points of view. So we hope that today's symposium was beneficial to all, not just women, but to the general population, because surely we need the collaboration of everyone to effectively combat discrimination and violence against women and all individuals in society, but in particular women, of course, today being International Women's Day. And I particularly enjoyed how this day is special and also symbolized through flowers, although we do not have specific flowers in Turkey for women, but flowers surely are an important hallmark of Women's Day, and hopefully we will go beyond that statement as well, and we will only present women with flowers in against a positive background, but not the issues that we're encountering today. Although I also have a lot of questions and comments about all of your presentations, unfortunately, we have to end this session, and it's been a very long, great day, but it's been definitely worth it. And thank you in particular for your recommendations regarding how to solve this situation, so that we might end today on a positive note and look forward. So I thank you all again for taking the time and being with us and sharing your very invaluable thoughts and experiences. And thank you to all of our participants for bearing with us today, and also enriching our discussion with their questions and comments. And of course, I would like to thank the organizers of the session for their efforts in putting this event together. So thank you all, and I wish you, I congratulate you Women's Day again, and wish you all the best and health, of course.